Good afternoon, good morning, good evening, wherever you are. Welcome to the show, Employment Law Show. We love doing it. It's been a long time. What's even been longer, Lior, is our radio show, which I'm going to get to in just a bit, how you reach out to that. But to reach out to Lior and his team anytime, here's how you do it. John Scholes here beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP. They're the most positively reviewed law firm across the country, coast to coast to coast. You can check that out. 1-855-821-5900. Don't hesitate to make that phone call. Just have a chat with Lior, member of his team. Email help@employmentlawyer.ca and shrink that down to employmentlawyer.ca. That'll take you to the firm website. There's a media tab, all kinds of stuff to be gleaned from the website. You can learn lots, but the media tab will direct you to one of our radio shows across the country. But more on that a little later on. Lior, on the show today, key things employees need to know about workplace stress. Hugely topical, especially over the last couple of years with COVID-19 continuing the pandemic. So we want to get to some of the broad strokes on that topic. But first, we always start. I throw it back to you for a week that was. Pal, what do you got going on?
John, it's always a pleasure to be here. Even us old folks sometimes take some break from our regular job so we can talk about employment law here on TV. And what I try to do is to try to answer as many questions as possible, and on this TV show, we take some of the issues, the questions that I see in my practice, and we try to synthesize them into this 30 minutes and try to cover as many of the relevant topics as possible. So we're going to cover anything from wrongful dismissal to severance, constructive dismissal, harassment, stress, you name it, we're going to cover it on this show as we do every show. And if what we say here either is not exactly what you're dealing with, or maybe it just leads to additional questions that you have, please remember, you can reach out to me off air. We can have a chat by phone. We can correspond by email, so we can resolve and deal with your workplace issue. A lot of people have been calling me, obviously, over the past 6 months with vaccine mandate questions. We've been dealing with that. We've been resolving these cases. Whether that's your issue or something else completely, you remember the law provides for good entitlements. Anytime I hear someone says, "Oh, we don't have good employment laws in Canada," it's because they don't know any better. They don't know exactly how good a laws we have. Some of the best employment laws in the world are in Canada. Yeah. Law can't help you, though, unless you give it that opportunity. And by listening to this show, by calling me at the office, you'll give it that opportunity. You'll be armed with the knowledge. So that's why it's so important that we do this show. And to start off, as you said, let's talk about the situation that came across my desk. So on this show, John, we've talked many times about the severance that someone is owed when they lose their job. Yep. But did you know you actually can get severance and compensated even if you've never worked for the company? So this situation I have is a great example of that. This lady had worked in a marketing position with her employer for a couple of years and ultimately accepted a job with a new employer. She thought it would be a great opportunity. They negotiated the terms of employment. She was going to make a bit more money. She was going to have a bit more vacation. She was very happy with it. She quit her job. They had a nice little going away party for her at that other job. They liked her, and she was getting ready to start the new job. Well, 3 days before she started the new job, or she was supposed to start the new job, she gets called by her new boss, the soon-to-be new boss, and saying, "Listen, unfortunately, with COVID, we had to do a restructuring of our marketing department, and we actually are not going to have a job for you. I feel terrible about this. I hate to do this to you. We love you to death, but there's just no job for you with this new company." So she was, of course, upset, and actually she was furious. She quit her job. Now she's left without any position at all. She liked her previous job. So what does this mean? Well, John, even though she never worked for this company, they have a responsibility for her. She quit her job. She relied on this new company saying that she has a job to the point that she actually quit her job. So because of that, they can't just let her go or not employ her and assume that there's no obligations. Because she relied on it, because she lost something financial by quitting her job, they have to compensate her. And it's going to cost them a few months' salary, probably about 3 to 4 months' salary they're going to have to pay her, even though she never worked for the company for a day. So why am I mentioning it here? Because it does happen. You believe you have a job, you've negotiated terms, then they change their mind, then they withdraw the offer. Well, they can't. The new company can't just do that. There could be legal consequences. If that happens to you, and I've seen that happen a number of times, give me a call and let's talk about what you're owed.
Would they be responsible for entire previous service with the old company? Say she'd been there for 25 years and left that job. How much would they be responsible for?
So they would be responsible for what would be considered a reasonable time to find another job. So a few months' pay does depend, depending on the type of job that she was going to be looking for, the age. It could be months and months' pay. Usually, it would be more likely about 3 to 4 months of severance that they would owe in that situation if she never even worked for the company. But yeah, depending on the position, it could be even much more than that. That's why, again, so important to call and get some advice if you find yourself in that situation.
You know, it kind of gave me an idea that something we've kind of talked about as well. That is, if somebody gets hired by a new company under a contract, say a 3-year contract, and all of a sudden the company they start working for after 6 months says, we're out of work, we don't really need you, so off you go. What happens in that circumstance?
Well, generally speaking, if you're sign an employment agreement for a fixed term, a year, 2, 3, whatever that fixed term is, if the company wants to let you go before the end of the term, they have to pay you the balance of that contract. And I did a case some years ago where someone signed a 7-year contract. It was let go after a few months, and the employer had to pay the balance of that contract. They ended up rehiring the person, of course, once they realized what they have to pay. So that's the general rule. So you could be owed a lot of money. Sometimes, let's say you're working as a mat leave replacement, and you signed a contract for 12 months, let's say. What happens if the person that's on mat leave comes back earlier from mat leave? Well, you may not have a job, but the company still has to pay for the balance of the contract because that's what you've agreed to. So very important to keep your eye out on that.
Again, any confusion, any questions that this brings out throughout the half hour, just reach out, right? 1-855-821-5900 or help@employmentlawyer.ca. Employmentlawyer.ca, the website is where you go under the media tab to find a radio show somewhere across the country that will serve you for an hour or half hour, however long the show is. Tons of interest, lots of phone calls come through the radio shows. We answer them every week, Lior, and we like to play some of them back here on this show and talk about them. Phone call number 1 is coming right now, my friend.
Worked for a bank for 12 years, and I was on short-term disability, just going on to long-term disability. I got a call from HR telling me that my position was no longer. They gave me a severance package of a week for every year. However, if I found a job, they would stop paying me.
So there's a couple of things to dissect here. So the first thing is, if she's now transitioning from short-term to long-term disability, presumably that's because she's not ready to come back to work yet, right? Otherwise, she wouldn't be going on long-term disability. So how does the company know that it doesn't have a job for her when she's not even ready to come back to work? It may not have a job today, but in 9 months or whatever it is, when she's ready to come back to work, at that point, they may have a job for her. So just by the company saying, we've decided, even though we have no idea when you're coming back, we've decided that there's no job for you anymore, that in itself is inappropriate. That in itself could potentially be a human rights violation by the employer jumping the gun. It's one thing to say, employee, today we don't have a role, but that could change by the time you're ready to come back to work. That's fine. But to say that now and to terminate her, that's going to be potentially illegal. So that's issue number 1. Even if we forget about this issue number 1, there's issue number 2, which is how much severance should she be getting in this situation. Now, if she's worked there for 12 years, she's offered 12 weeks. A lot of people may think, well, it's a week per year. That's kind of the standard. That's the norm. Not even close. It's not the standard. It's not the norm. It's not what the law says at all. So what does the law say? What should she be getting after 12 years? Let's use our severance calculator, of course, which you can find at pocketemploymentlawyer.ca. Let's plug that information in pocketemploymentlawyer.ca, and let's see what that gives us. So we know that she's in banking. She's been there for 12 years. She was offered 12 weeks pay. You can see there that she's owed much more than that. She could be owed north of 16 months pay, okay? North of 16 months pay is what she's owed, not 12 weeks. That's a huge delta, a huge, huge difference. Now, that's assuming the termination itself is legal, which it's probably not in any event. So this person really needs to call me in the office so we can have a chat. And an important reminder there for employees off on disability, you can't be let go while you're on disability. And of course, on disability, off disability, young or old, doesn't matter. Your severance must be reviewed before you sign it. Chances are you're owed a lot more than what you've been offered.
There is yet another place for you to ask questions anytime. The website's called terminationquestions.com. Don't worry, it's anonymous and it's free, so you can use that anytime. Again, terminationquestions.com. First one for today, Lior's coming from Brittany. Writes in and says, last month my employer unexpectedly added a heap of new duties to my job that nearly doubles my workload. I told my manager that while I can handle the added tasks temporarily, it can't be a permanent change. I believe I will soon be let go because of my complaint. Can I stop that from happening?
And that's a question, John, or I get often. You know, I think my employer is going to let me go. I don't want to lose my job. Can I prevent that from happening? Ultimately, you cannot stop your employer from letting you go if they're going to do it. Even if the termination itself is illegal, you can't physically restrain them. Okay, you can't. There's no employment law police that comes in and says, no, you're not allowed to fire someone. You're going to lose your job if that's what the company wants to do, but they're going to have to pay you severance. Now, in this situation, this person could have decided to end her employment herself. Brittany could have by saying, by adding these duties, you've changed the terms of my employment. That's a constructive dismissal. Now you have to pay me my severance. She didn't do that. She told them that she's going to work and do that for a while. So she's actually being the good soldier. So if she gets rewarded for being the good soldier by being let go, that's a kind of a crappy thing for the employer to do. Ultimately, though, it comes down to severance. She cannot lose her job without severance because she complained, not at all. She's going to have to get paid her full severance after 2 years' pay. So what I would say to Brittany, if you do lose your job, you want to call me right away so that we can make sure that you got everything that you are legally owed.
And with that, a short break is upon us. When we return, key things employees must know about workplace stress. That is on the way. 1-855-821-5900, the number anytime to reach out. And that email address again is help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thank you so much for sticking around. Employment Law Show. With me, of course, Lior Samfiru, co-founding partner, Samfiru Tumarkin, LLP, most positively reviewed law firm in this country. The topic for today, Lior, I know you're one of your champion of the bit to get into this. Key things employees need to know about workplace stress. Point number one, workplace stress can cause both mental and physical impairments that affect an employee's performance. Expand on that, pal.
Well, John, I think the last 2.5 years gives us the best example that we can ever have.
Right.
With the pandemic, we've all experienced stresses at work and off work. And certainly going to work for many people was added stress. Now you're exposed to the virus. You're working with others and you're not sure about the exposure there. Maybe your business is struggling. Maybe your job is changing. And that is all stress. Add to that the fact that you have stressors at home tied to the pandemic and otherwise. So, and those can manifest themselves in different ways for different people. Some people may kind of bottle it all in and they continue working. At some point, it may explode. Other people will have either physical or mental effects. I have seen so many people go off work because they can't deal with that stress, because that stress is too much. It impacts them and sometimes go for a very long time. These are legitimate matters. Gone are the days when we question or don't believe people because they have a mental health issue because it's related to stress or anxiety, depression. Now we understand that these are legitimate, these are serious, and they can be debilitating. So when it comes to employment law, you have to understand that there's going to be times, whether it's because of workplace stress or maybe other stress, that you cannot work or it's too much. And that's why there's laws to protect you in those situations, to maintain your job, to maintain your compensation, to ensure that you have rights. So that's exactly what we want to talk about in this segment.
Yeah, it's interesting. That brings about the second point. Gone are the days where, the boss says, suck it up, just go have a coffee and a cigarette, you'll be fine. No, employers have a responsibility to ensure mentally and physically that their environment's safe and welcoming for their staff, right?
One of the most important responsibilities that an employer has, maybe the most important responsibility, is to make sure that the workplace is safe. Now, that doesn't just mean that it's safe in terms of the machines are in good order, right, that there's no stuff that you can slip and fall on. Obviously, they have that obligation, but it goes beyond that. They have to ensure that you have the support you need to do your job properly, that you're not exposed to unavoidable stress and anxiety, that you're not mistreated, that the workplace does what it can to ensure that it's proper for doing work. So it's not just, well, we give you the machine and we don't have anything else to worry about. Your employer has to be aware of the work environment. Your employer has to be aware how people are being treated in that environment, and ultimately to fix whatever workplace problems there are when it causes undue stress. And if an employer ignores those responsibilities, there's consequences. That can result in a constructive dismissal. That could be a violation of the occupational health and safety legislation. So as you said, John, gone are the days where an employer can say, that's not my problem. If there's something going on in the workplace that impacts your employees' mental well-being, it is the employer's problem.
Again, we're talking about key things employers for that matter must know about workplace stress. We're kind of drilling down on this topic today, Lior, because it's so important, especially as you mentioned over the last 2 years, it's really come to the forefront. Number 3 is this: an employer must provide accommodation to an employee experiencing undue stress and their ability to do their job. How about that?
So first of all, duty to accommodate, we know of it in other contexts. So for example, if you had a bad back and you need some support to do your job, then your employer has to provide that accommodation, modify duties, provide assistance, etc. Well, the same thing if the medical condition arises from a mental health issue. So your employer may have to provide accommodation, maybe that changing your hours, reducing your hours, changing your shifts, maybe even finding you a different role that has different levels of stress, because your mental health is just as important as your physical health. And how do you get that accommodation? Well, you get it by speaking to your doctor. Your doctor needs to be able to say, for health reasons, this is what the person needs. They don't need to, by the way, say it's because of anxiety or depression. They just need to say, for medical reasons, here's what the person needs. As soon as you have that, then your employer is under a very strict legal duty to provide that accommodation. If they don't, there's consequences. You need to call me. But yes, mental health has to be accommodated, and your employer has to follow what your doctor says.
And next point kind of follows that nicely is an employee can take a job-related protective leave or go on short-term disability through the company's insurance plan, right?
So yes, obviously, if you can't work because of mental health issues, stress, anxiety, etc., then you absolutely can be off work. Again, we need that doctor's note, of course. We need the doctor's note to provide you with that time off, and your employer can't question it. They can't ask for more information about what the condition is. They can't demand that you see another doctor. No, they have to follow what your doctor says. Of course, if you have a disability plan through your work, short-term disability, long-term disability, you can apply for those so you can get paid by the insurance company. If not, then there's other benefits available, EI benefits, potentially CPP disability benefits. So there's benefits available to you, even if you're not able to work because of mental health issues. But again, how do we get it all started? We get it started with that doctor's note.
And this one kind of switches the spotlight over the employer, and that is employers can't punish or reprimand or penalize employees for complaining about stress-induced job problems, issues at the workplace, yeah?
No. In fact, not only can they not punish, they must by law take it seriously, to investigate whatever the issue is and to try to rectify it and to meet their legal obligation. So an employee, I should say, that is struggling with workplace stress, harassment, bullying, you name it, not only is it a good idea to tell your employer, I strongly recommend it. You can't be fired, you can't be punished, you can't be suspended. You have what I call that dome of protection around you. So you should always feel comfortable to talk to your employer about these things. If you've spoken with your employer and they dismissed that complaint, they didn't take it seriously, let me get involved and let me make sure that they take it seriously, because guess what? They absolutely have to.
And this last point, Lior, really wraps it up, and that is an employee can leave their job with severance pay if their employee fails to properly deal with the source of the stress and or anxiety.
So we've spoken about the employer's responsibilities to ensure a safe work environment, to accommodate, to take issues seriously. If the employer doesn't do that, that's a fundamental breach of terms of employment, meaning you, the employee, can say, well, employer, by not doing what you're supposed to, by exposing me to harassment, to stress, to bullying, more than I should be, you've essentially terminated my employment. We call this constructive dismissal. I can then leave and make you pay me severance. So even though you're the employee choosing to leave, your employer is going to have to pay you severance. Now, I don't want anyone leaving or quitting without speaking to me first, okay? Because we have to do this right. We have to make sure that we properly build the case and document it properly. But yes, you absolutely have the ability, if your employer doesn't support you, doesn't protect you, doesn't meet their obligation, to leave with severance.
Again, the website employmentlawyer.ca will give you contact information, also give you a good route to one of our radio shows across the country. Phone call number 2, Lior, from our radio shows is coming up right now.
Talking about employment agreements and everything, a lot of times I'll see through an agreement subject to change at any time. I was just curious, are there any lines or boundaries that they have to follow with that, especially when it comes to something like hours or pay or anything? Or is it just because they put subject to change at any time, it's pretty much a free-for-all? They can do whatever they want, whenever they want, with whatever that clause is?
Excellent question, and a smart question to ask. So I've said many times on this show that an employer does not have the right to make significant changes to terms of employment. You've heard me say this hundreds of times. That means your employer can't just reduce your pay, can't demote you, can't relocate you. They can't do that unless you sign an employment agreement that explicitly gives them the power to do so. So if your employment agreement says, we, the employer, can change your pay, then guess what? They can, because you've agreed to let them do it. If it says, we have the ability to change your job duties, they can do it. We have the ability to relocate you, then they can do it. So yes, if an employment agreement says that we have the ability to change, like this person was asking, then essentially you're agreeing to get paid whatever they want, to do whatever job they want to give you, and to work wherever they want. Don't do that, okay? Don't sign an agreement that gives the company the right to change those terms unilaterally. You can negotiate these terms out of the agreement, okay? You can, and if you're already working and your company wants you to sign a new employment agreement that gives them all these powers, just say no, okay? They can't force you, they can't punish you for refusing. You don't want to be in a situation where your employer can do whatever it wants to your job without having any recourse. And again, if you're not sure, give me a call.
Yep, that employment agreement can either, you can sink or swim with that one, so do not sign anything new or old without reaching out to Lior. How do you do that? Email help@employmentlawyer.ca, and the phone number, 1-855-821-5900. Lior, short break. We got a bit more coming up, so stick around for that as we continue the Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thank you so much for hanging in. Last few minutes of the show, I want to slide in, Lior, one more phone call from our long-running radio show series across the country. It's coming up right now.
The company I work for has been sold. From what we're being told from our bosses, that there's two different types of sales. One is assets only, and one is assets including all the employees. If the company wants to let people go, I would assume they would have to pay the severance that the employees had with the old company. Am I right?
It's a great question. Great question.
It's a great question. And by the way, this happens very often, much more often than you realize when there's a sale of a business. Happens all the time. So let's break this down and what happens here. Ultimately, the question is, are you out of a job? If you're out of a job, you're going to get severance. Now, if you started working with a new company and then the new company lets you go, then the new company owes you severance, and they do have to account for the time you had with the previous company. They inherit your service, and they have to pay you severance. Now, be careful. If you start working with a new company, you don't want to sign an employment agreement that gives up your prior service. But unless you sign an agreement that gives up your prior service, you start working with a new company, then they say, you know what, it's not working out, they let you go. Severance gets paid, including the time with the previous company. Now, if you never started working for the new company, there was a sale, the new company never hired you, and you lost your job, absolutely you get your severance. And the seller, the old company, is the one that's on the hook for that. They terminated your employment because they sold the business. They have to pay you your severance. So in some situations, the buyer is going to have to pay you severance. In other situations, it's the seller. Either way, if you lose your job, you get paid severance. And if you want to find out, I said it before, how much severance you're owed, easy, always just grab your smartphone, tablet, whatever you want, go to pocketemploymentlawyer.ca, use our severance calculator, find out in seconds how much you're owed, by the way, free and anonymous completely.
Does it make a difference if when this company is sold and things kind of change hands, you think this is a good time to jump ship and maybe go back to school or travel the world or whatever? Does that change the metric at all?
So if you're offered a job by the buyer and you choose not to take it, generally speaking, what happens is you're still going to get severance, but much less. You're only going to get your minimum severance amount, not your full severance amount. So that could be the difference between getting, 8 weeks pay and 20 months pay of severance. So some severance is still going to be owed to you. If you're not sure how much, let's talk about that. But even in that situation, you still have to get paid.
TerminationQuestions.com. We'll get to one more of these, Lior, for the show today. Comes from Charles. He writes in, says, I'm a 62-year-old field technician with 23 years at the same company. My new supervisor has been increasingly complaining about my quickness and efficiency. I believe his dislike towards me has led to a dramatic reduction in my shifts. What can I do?
So the first question is there really a reduction in Charles's efficiency and quickness, or is it just the boss picking on him? If it's not legitimate, if it's not actually happening, just kind of a bad boss that's picking on him, well, the fact that his shifts are being reduced, that's a constructive dismissal. So Charles can't stop that from happening. You can't force your employer to give you more or better shift. But what you can do is say, well, my shifts used to be 5 a week. Now you've reduced me to 2 or 3. That's a constructive dismissal. I'm choosing to treat this as a termination. Now you have to pay me severance. He's been there for 23 years. That could be owed 18, 20, even 24 months of severance. Now, that's issue number one. But if Charles says, I have been slowing down, but because I'm dealing with some health issues, then what Charles needs to do is get a doctor's note saying, just so you know, Charles is struggling with his health, so he's going to need some accommodation and support. At that point, he can't be penalized by his employer because, again, it's not his fault. He needs that doctor's note. That doctor's note protects him. Either way, he has recourse. He has options. And I would tell Chuck to give me a call, and so we can have a chat and make sure that his rights are enforced.
And again, just to reiterate, we've talked about this on past shows as well. There is no, he's 62, but there is no mandatory retirement age. So 65, out you go. That's long gone, right?
So when I started practicing law many, many years ago, yes, we had mandatory retirement. And in most provinces, yes, your employer can make you retire at 65. That's gone. You can work till 70, 75, 80. And I've spoken with many people that are working well past 65. You have that right. You can't be punished. You can't be threatened. If that ever happens to you, call me.
And that's how we're going to end it for today. Feel free to reach out anytime to Lior. That phone number, one more time, 1-855-821-5900. Email address we always use is help@employmentlawyer.ca. And that website, it's free and anonymous to ask your questions, terminationquestions.com. Again, terminationquestions.com. Go there anytime. We'll catch you next time. Thanks for tuning in to the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.